Good morning. Well, thank you to Sandra for inviting me. My name is Kimberly Ishmael. As you all know, I was an attendee at the PIM toolkit launch back in 2008. So I was actually quite happy and pleased to, after being at the launch of the toolkit, to be asked back to speak on the topic of privacy breaches. So what is a privacy breach? A privacy breach occurs when there is an unauthorized access to, or collection, use, or disclosure of personal information. Such activity is unauthorized if it occurs in contravention of applicable privacy legislation. When we're relating privacy laws to school boards are affected both by MFIPA and PHIPAA. A school board is governed by MFIPA, and a psychologist, social worker, a speech-language pathologist who collects, uses, and discloses health information as part of their services are governed by PHIPAA because they meet the definition of a health information custodian. Now, not all individuals will meet that definition, so that's something you'll need to analyze on a case-by-case basis, depending on the relationship of the psychologist, social worker, or speech-language pathologist and the board, and how the services are being provided. Violations of personal privacy frequently involve the inappropriate or inadvertent disclosure of personal information, contrary to Section 32 of MFIPA or Section 12 of PHIPAA. And Section 32 is the provision, for those that are not as familiar with the legislation, that allow for disclosure in a limited number of circumstances. PHIPAA is the security provision of PHIPAA. So some examples of an inadvertent or inappropriate disclosure would be where personal information is lost on a USB key, or a file is misplaced internally in office, or there's a stolen laptop. Inadvertent disclosure through human error, where there's a misdirected fax or a letter is copied to the wrong party or the address is incorrect. There are also intentional disclosures or intentional misuse, and there's a number of factors. There could be a laptop on a teacher's desk, and a student thinks it's a prime opportunity to stick in their own USB key and get class grades, class names, that sort of information, if it's not protected, and we'll discuss that later. Or it could be a service provider who's responsible for the shredding of documents, but it'd be more cost-effective for them to recycle, and that would be another unintentional misuse. Violations of personal privacy can also occur by unauthorized collection of personal information, contrary to Section 28 of MFIPA. And that's the provision that explicitly requires the standard form, for example, to identify that personal information is being collected, and that needs to be included on a standard form. Now, when we're discovering a privacy breach, how would an institution find out? Typically, it's either directly from the affected individual, say, for example, the student who determines, or the student's parent, who determines that their information has been disclosed inappropriately, or it could be from the staff member who identifies to their superior or to board administration that they've lost a laptop or their USB key. It's also comes to a school board's attention indirectly if it's in the media, if the IPC learns of it and wants to conduct an investigation, or if a call is made, but the identity is unknown. The first step, and while you'll see throughout the presentation, I've listed them as steps 1 through 5, really this is going to be happening simultaneously. And for those of you who have attended the PIM toolkit or have your references with you, you'll see that we've also included them there as 1 through 5. But this is really happening simultaneously with a number of different parties. And Sandra will speak to some of the roles and responsibilities. The first step, we'd say, is to respond. You want to assess the situation to determine if a breach has occurred and what needs to be done. In some circumstances, there may be a secretary who will come to you and say, I've lost a subfile, and it includes personal information. But it wasn't exactly lost. She had to look amongst some other files. So that was just an internal misplacement and not necessarily qualifying as a privacy breach. You want to ensure that the appropriate school board staff are immediately notified of the breach, and that would include your FOI coordinator. You want to implement the privacy breach protocol, or if you have a procedure in place, that would be the opportune time. The next step is to contain, and this is the most important. You want to identify the scope of the breach and take steps to contain it. Examples would include retrieving hard copies of any personal information that have been disclosed, determining whether the privacy breach would allow unauthorized access to any other personal information, and that would include upgrading security measures at the board, or upgrading passwords, changing passwords, that sort of thing, depending on what the breach and the extent. And throughout this process, you want to be documenting the breach and the containment activities, because you're not aware at this point if there would be a complaint, and you want to make sure that the board has been documenting all of its activities. Step 3, what we'll call step 3, would be investigate. You want to conduct an internal investigation into the breach, reviewing the circumstances surrounding the event, as well as the adequacy of existing policies and procedures that are currently in place to protect personal information. So when you're conducting this investigation, you're saying, why did this happen? How did this happen? Who did this involve? What type of personal information was disclosed? What was the cause and the extent of this breach? The individuals that are affected, and what is the possible harm? And it is when you're doing that investigation that you're looking at the next step, which is to notify or not to notify. For those of you that have reviewed the PIM toolkit and some of the IPC's materials, you'll see that frequently, or more consistently, they would require and recommend that you be contacting the IPC on every breach. We would say that there's a decision that needs to be made as to whether to notify or not, and that's why I've titled it, to notify or not to notify. If the breach relates to personal health information, there is a mandatory requirement of breach notification, and that's under Section 12, Sub 2 of PHIPAA. The provision provides that a health information custodian that has custody or control of personal health information shall notify the individual at the first reasonable opportunity if the information is stolen, lost, or accessed by unauthorized persons. So when you're investigating, you're determining what was the information? Is this personal health information? Was it a health information custodian? And is this provision under the Act engaged? And if that's the case, then there's a requirement that you shall notify at the first reasonable opportunity. And if a complaint were filed or the IPC were to investigate, they would be looking to see whether that was done, and it was done in a timely manner. Now, keeping in mind, there are a smaller segment of the school board population that would qualify as a health information custodian. So there is much more discretion when you're looking under a privacy breach under MFIPA. And so if you are deciding to notify individuals, you want to provide as much information as possible. And a lot of that will depend upon what you investigate and as much information as you're able to obtain. You want to include information as the nature of the breach, the mitigating actions that were taken by the board, and depending on what information was disclosed, if there's a possibility for identity theft, you want to provide them with additional information, a contact number, or a means, say for example, if it's credit card numbers, to contact their credit bureau, cancel credit cards. You also want to consider if it's an OEN number, parents are going to be very concerned, you'll want to notify in those circumstances. But this is a decision that you're going to have to make following your investigation. It's going to be in consultation with your FOI coordinator, likely senior board admin, so this won't be made by one person. This is likely going to be in part of your investigation once you've looked at all those factors. The same goes with notifying the IPC. Reporting to the privacy breach to the IPC is needed depending upon the circumstances. A board may determine that the breach is too severe and that they haven't handled it well and that they need further recommendations, and they will contact the IPC. And the IPC, as I mentioned, does recommend that you do that in all circumstances. If the board, however, has determined that the breach has been contained, they have notified the necessary individuals, and they've contained the breach, there is not necessarily a legal requirement to notify in each circumstance. When you're looking at whether to notify the IPC, you're looking at those same factors again. The type of personal information, the cause and the extent of the breach, the individuals that are affected, the likelihood of a complaint. And that's always what's looming, it's the likelihood of a complaint. If we're dealing with OENs, if we're dealing with personal health information, social insurance numbers, those are areas where we're going to want to be in consultation to determine whether we need to contact the IPC. And step 5, we're implementing change. You want to address the situation on a systemic basis. School board procedures or practices may warrant review or revision, and the breach may identify some gaps in employee training or their understanding of the policies or procedures that are in place. You want to evaluate the response and determine the effectiveness of the remedial action. So part of when a breach occurs is that it needs to be timely, and if it's not timely, then you want to have this opportunity to look at how can we change the way that the system currently is run to make it more effective. So those are basically the 5 main steps that in the PIM toolkit you see it referenced at how to look at dealing with a privacy breach. And so I mentioned this is sort of going to be happening likely in a very short span of time, including a number of different individuals. So looking at some proactive measures to avoiding privacy breaches, there are a number. The first being comply with the legislation. And that sounds sort of, the basic general one, but it's one that needs to be included. We know that there are privacy laws governing the collection, retention, use, and disclosure of personal health information under MHIPAA and PHIPAA, and we want to ensure that we have policies and procedures in place that do address those legal requirements. Another suggestion is to ensure that appropriate clauses for compliance are in your legal agreements with service providers. So if you have service providers that are coming into your schools or that you're contracting out services to, you want to ensure that they have an obligation to report to you in the event that there's a breach of student information, so that those clauses are there, and it's not just a general one to know that they're also governed by MHIPAA if they have access to that information. But thinking about it practically speaking, when will they identify that breach to you, and what will you do in response? So you'll also want to obtain advice from your board's legal department and your FOI coordinator, and that can be at a number of different times. When you're creating your policies, in implementation, if it's a smaller breach that you think you can handle yourself but you still want guidance, the FOI coordinator is your first point of contact. You want to consult with the IPC's policy and compliance department, and often a lot of privacy breaches are dealt with informally. So you won't see a formal order if you were to go on the website or look at legislation, some of the orders from the IPC, because it is just a phone call. Literally, someone's calling the IPC and saying, this is the situation, this is the scenario, and what are your suggestions on how to deal with it? Another suggestion is to consider random spot audits of privacy policy compliance. And that's the same example. What I was referring to earlier with service providers. You want to spot audit your providers. If you're contracting out the shredding of personal health information, conduct a personal spot audit or random spot audit, and see whether that's actually being done. Because there are a number of cases where documents are being recycled, thrown out in the garbage, because it is more cost effective. It's a simple example, but a spot audit can be done with service providers, and it can also be done with employees. And that can be that their laptops are password protected at all times. And what we suggest, although I know some have some concerns about why that would be done, is to embed it into the job description, because that's when people pay attention to privacy and the importance of privacy, including it as part of their job description and evaluating them on it. Even if it's just as a teachable moment, a principal walking into a classroom, sticking in a USB and getting information from a teacher, and then being able to call them aside and say, there's some privacy issues here. That's a teachable moment. Because ultimately what we're trying to do is to develop an information awareness, a culture that respects privacy, we're mitigating the risk, and that could have been a potential privacy breach that the principal then identified. So we have the benefits of a privacy breach protocol. I'm hopeful that most of the boards are getting to a point where they should have one in place, or that they're thinking about getting policies and procedures in place that speak to what would happen in the event of a privacy breach. What a protocol does is it helps to mitigate the damage by immediately preventing further inappropriate disclosures of personal health information or personal information. It assures the complainants and the affected persons, as well as the public, the media, and the IPC, that the matter is taken seriously. We are always aware in public sector that that piece is important for families, for parents, to know that the board takes the personal health information and personal information of students seriously. We want to ensure that the policies and procedures comply with privacy protections, the provisions under MHIPAA and PHIPAA, and that staff are, of course, appropriately trained. And that's by having a breach protocol, it allows for that training to take place. So I've taken a look at some recent cases, and I referred earlier to the fact that there is not a legal requirement for institutions to contact the IPC on each and every case of privacy breach. So you'll note that there's actually less orders for privacy breaches under MHIPAA as there are in PHIPAA, because there is that legal requirement. In this first case, which is dating back to 2006, there was a laptop belonging to an employee of a school board that contained personal health information of 37 students that was stolen. Now, this laptop was a psychologist who was a previous employee at another board. So they had left that board, gone to a new board, and then the laptop was stolen, but they still actually contained the assessment reports from the students that they worked with at the prior board. So the IPC was involved and investigated and advised the board that the assessment information had been disclosed. Section 12, the requirement to notify, was met. They sent notification letters to the students' parents advising them of this. And the psychologist, there was a policy under, the board's policy did include specific direction that they should not contain personal information on their laptops. However, this employee hadn't implemented that board policy. So the complaint was resolved by way of informal resolution, and the health information custodian agreed to update their policies and procedures to ensure the compliance with the Act, and additional educational measures were undertaken to ensure that staff were aware of their obligations under the Act. This is an interesting circumstance, teachable moment. And note that in 2006, we don't have any information relating to whether the information was encrypted, because if it was encrypted, the IPC likely would not have viewed this as a breach. Now we have an order under MFIPA. There's a complaint alleged by a student that a teacher verbally disclosed a student's probable grade on an art assignment with 2 other students, contrary to MFIPA, and this is dating back to 2003. The IPC confirmed that verbal disclosure of personal information falls under the privacy provisions as long as the information exists or existed at one time in a recorded format. Now, in this instance, the grade was probable, and so it did not match the student's recorded grade. And so the IPC found that it did not qualify as personal information under the Act, and thus it was not a privacy breach. However, in their investigation, they questioned the school's practice of relating to the display of artwork. To give you some of the context behind it, the artwork was displayed in the school with the student's name on the front and their grade on the back. But students had the ability to turn the artwork over to see the student's grade. And that practice, or that access, would have been unauthorized. And so in their investigation, they found that that access was unauthorized, and the school lacked reasonable measures to prevent the unauthorized access. And that's something I think is common in artwork in schools that people may not be thinking of. So if it's not in glass enclosed and students could walk up and turn it over, they would have been known the student's recorded grade and name. So the IPC recommended a board policy to prevent the unauthorized disclosure of student grades, specifically addressing the issue of verbal disclosures as well as the issue of displaying students' assignments. Now, there also are some circumstances where a teacher may be in a grocery store, may bump into another teacher in passing, and I think although now we all think we're pretty aware of privacy and the confidentiality of students' names and information, a conversation can be quite open when the teachers are quite comfortable with one another, and it's easy for them to disclose grades, how well a student's doing, not being aware of who else is there. And so these sorts of informal discussions are often unauthorized disclosures of personal information, and students, staff, teachers need to be aware of that. You may have all heard of the privacy breach at the Durham Health Department that was quite recent. On December 21st, 2009, the IPC was notified by the Durham's Officer of Health that a nurse had lost a USB memory stick containing the personal health information of over 83,000 individuals who had attended H1N1 immunization clinics in Durham. The personal information included names, addresses, telephone numbers, dates of birth, health card numbers, and health history. The memory stick was not encrypted, despite the fact that the encryption of mobile devices was required as of the IPC order back in 2007. Now keep in mind this is under HIPAA because this is personal health information. The IPC issued an order on January the 14th of 2010, clearly outlining the IPC's expectation that all personal health information stored on any type of mobile device in Ontario be protected with strong encryption. Now, taking a look at this decision and the previous one of the psychologist, we note that that information was not protected when the psychologist moved to the new school board and still retained the assessment reports for 37 students on his laptop. In this case, we see a number of personal health information that's included on a memory stick. It's very simple to lose a memory stick. IPC is demanding that it be encrypted. And so I know a lot of school boards are using memory sticks, they're using laptops, the students are using them. This is something that the boards need to be taking a look at because the IPC has made it clear that strong encryption is required. And even more recent, there was a theft at OTIP. There were 3 laptops containing addresses and social insurance numbers of approximately 8,600 elementary teachers that was stolen from an OTIP office in Waterloo. And that was on December 3rd of 2009. The laptops had been locked to docking stations. The information contained on the laptops was not encrypted. OTIP notified any teacher members whose information had been compromised by letter advising of the incident, and they provided a toll-free number to the recipient to contact them in the event that they required further details. The OTIP spokesperson stated that it took fraud experts nearly 2 weeks to pinpoint what the information had been that they'd lost, and the holiday break delayed the process, so affected teachers were informed in mid-January. They stated that because of what's happened, we're working faster to encrypt all of our communication devices by March of 2010. Now, when you're looking at the 5 steps of addressing a privacy breach and look at this one, hopefully this scenario raises a number of concerns. Yes? I hope. The first one are that the laptops are locked to docking stations. And if that's the extent of the security measures, well, I think that's inadequate. The locking stations were broken and the theft occurred. Now we also have the theft that occurred on December the 3rd, and they allowed the holiday break to pass before they notified. People were not notified until mid-January, and that is an inappropriate length of time to notify individuals, especially considering this is the holiday season and the information could have possibly led to identity theft. Now, keep in mind, in this scenario, OTIP is not an institution under MFIPA, so there was no investigation conducted by the IPC, but OTIP was contacted by the IPC, and this was their comment. The other concern is that it took fraud experts nearly 2 weeks of forensic work to pinpoint what information had been taken. So they really had no idea, no database to say, this is what we've collected. And that's a concern. Anytime you have a privacy breach, in order to contain it, you have to have an idea of what sort of information you're collecting, retaining, using. That's all of the requirements under MFIPA. And school boards are required to maintain that sort of information. In this case, as I've mentioned, OTIP is not an institution under MFIPA, and so they did not have those requirements in this circumstance. So I hope that some of these examples have raised some of the concerns that we have when a privacy breach occurs. You've seen the 5 steps, and as you can see, it really comes down to containing and notifying. Most importantly, you're responding. You're responding by containing, notifying when necessary, notifying the affected individual if this is if there's SIN numbers, if there's OENs, if there's personal health information, and if you're using laptops, more and more school boards are, we should be moving towards encryption. Schools, for the most part, are very open environments. We have a number of individuals in and out of our schools on a day-to-day basis. And when you think about the security measures that can be in place, obviously there are always cost issues that we're having to address at all levels. But anyone can walk into an office. It's likely not required to have a swipe card or a pass card to get into the OSRs. They're not in a vault. So the extent of security measures can go up and up and up, but we want to be prepared to have a privacy breach protocol in place that allows the individuals who are involved, whether it's staff, teacher, to feel that they have the tools that are available to them to respond to that breach when it occurs. And there's a number of references that I've included, and this will be available on the website. It's a number of tools that the IPC has, as well as the PIM toolkit, which you'll find outlines the steps 1 through 5, as well as some information that's of use when you're dealing with a privacy breach. Thank you.